is actually based on the previous questions subject wise. We already discussed on the Constitution of India, and today we'll be talking about the CPC, Civil Procedure Code 906. The first question is which of the following sections of the Civil Procedure Code defines the mesne profits? The section 212 talks about the mesne profits. Friends, see, when we go through this one, it will give an idea. So like how the topics can be there. So here it is a question of mesne profits under section 2. It may be something else also. The reason is that we have the opportunity to use our bare acts. So at least we'll have an idea how the questions will be framed. Okay. And CPC, at least 10 questions we can expect. The next question is under CPC 1908, foreign court means it is a court situated outside India and not established by the government of India. Then under Civil Procedure Code, Section 9 talks about the pecuniary jurisdiction of the courts. See, this indicates that at least we have to remember certain sections of the important. Like Section 5 talks about the revenue, 7 talks about the provincial small courts, Section 9. So they may ask the pecuniary jurisdiction under which section? This is Section 9. Then recovery for specific immovable properties for the time limit is 6 months. The provisions under the Section 10 of the CPC are directory. So we have to know which section gives the directory nature and which are the mandatory. So here Section 10 is a directory. Constructive res judicata is explained under which section? It is a section 11 of the explanation 4. If party obtained an order to leave to amend pleading does not amend the same within how many days? Within 14 days, if it doesn't amend, then the amendment will not have any effect. So within 14 days, it needs to be amended. Section provision of the settlement of the disputes outside the court, outside the civil court is Section 18.9. This is where we have the ADR. Section 18.9 talks about the outside settlement courts. A plaintiff has to be represented to the court under Rule 6, Order 6, Rule 1 for any duplicate copy. Omission to give the notice under Order 21, Rule 22 renders the execution null and void. Where a decree is passed against the Union of India or the state government, the time limit of the notice is 3 months from the date of decree. This comes under the Section 82 of CPC. Which of the following statements hold true for de novo trials? A de novo trial should be the last resort. De novo trial is nothing but after exploring all the things, then the fresh case has to be started on the same topic or the same subject. That is a de novo, start from the beginning. Imposition of the compensatory costs in respect of the false or vexatious claims. Section 35A talks about the imposition of the costs for any cases they are considered as a vexatious or false. 35A. Which provision under the CPC deals with the substituted service of the summons? Order 5, Rule 22 deals with the substituted service of the summons. Decree holder means a person whose favor the decree has been passed or an order capable of execution has been made. Some questions are very easy. Just by looking at the question we can answer. Particularly with respect to the orders and sections, we just have an idea which order contains what type of a subjects, so that we can see the bare act and we can do it. We will have enough time to go through the bare acts because 3 hours, 30 minutes, 90, that is 120 minutes for 100 questions is a very big time available for us, even to refer to the bare acts. Suits by indigent persons is dealt under the Order 33 of CPC. Indigent person means the person who cannot afford any money, or who is a pauper, or who is a bankrupt, kind of a person who cannot afford the legal. Under Order 33 of the CPC, he can use that privilege. Provision regarding the filing of the suits by alien under the CPC. Alien means outsiders. So section 83, somebody who is an alien can file a suit. Sorry. An order issued by the court under the CPC 1908 as per the Order 21 Rule 46. It is a garnishee order. Garnishee order means if a person files a case against a person who need to pay him, but the person on whom the case is filed, he has some money with the bank. In such case, and he doesn't pay to the whoever is the person to whom he is the due for paying. In such case, the court can directly give the order to the bank directly to pay to the person who needs to get the money from this particular person. Okay, or a debtor. Section 88 read with Order 35 talks about the interpleader suits. Interpleader suits are important. See, the interpleader means between the two clients or two opposition parties, you try to create a pleader suit. That is a Order 35. Section 88 talks about the interpleader suit. The principles of res judicata is under the section 11. Section 14 of CPC deals with the presumption as a foreign judgment. Just need to remember section 14, presumption as a foreign judgment. A residing in Delhi publishes in Kolkata statement of defamatory of B. B may sue A. Here he can sue because he is the person who is affected. He can sue either from the cause of the action, place where the cause of action developed, or where residence. So either Kolkata or Delhi he can use the place to file a case. Which of the following is not legal representative? Executor or administrator, intermediary, Hindu co-persons, creditor. Intermediary is not a legal representative. Which of the following is not essential element of a decree? A decree need to have the conclusive determination of the rights, and it is a formal expression of the adjudication. It is also adjudication that is given in the suit before the court. Decree is not an adjudication from which an appeal lies as an appeal from an order. Which order has been specially enacted to protect the interest of the minors and unserved persons? Order 32 talks about protection of interest of the minors and unserved. Order 32. Which order of the CPC lays down rules governing the pleadings in the court? Order 6 place the rules governing the pleading in the court. Second appeal under section 100 is applicable to which of the cases? A substantial question of the law is formulated. Substantial question of law is not formulated by High Court. An appellate decree passed ex parte. All of the above. Answer is all of the above. Which of the following is not a requirement for a foreign judgment to be conclusive? It must be given in the, it is given by the court in an enemy country, which is not a requirement of the foreign judgment to be conclusive. It is by a court in an enemy country is not a requirement. Next question, a reference can be made during the pendency of the case. Subordinate court refers to the case to the High Court for a latter's opinion on a question of the law. Subordinate courts, whenever they have an issue in giving a final judgment, can refer to the higher courts for their opinion, particularly with question of the law. A person can apply for a review of the judgment when he is aggrieved by a decree or an order from which an appeal is allowed. He is aggrieved by a decree or an order from which no appeal is allowed. He is aggrieved by a decision on a reference from the court of the small causes. The answer is all of the above. In which of the following cases the remedy of the revision is not available? Remedies is not available where the cases in which first appeal lies, cases in which second appeal lies, interlocutory orders. These are all the situations where the remedy of the revision is not available. The term suit of a civil nature refers to the private rights and obligations of the citizens. Suit of a civil nature. As we know, the criminal is against the state or by the state. In case of the civil, it is between the private parties. The rule res sub judice implies when a subject matter is pending in the court for adjudication between the same parties, other court is barred to entertain the case so long as the first suit goes on. Sub judice means it is already pending in some court and other court cannot take it up, so subject to the condition that the case is same and between the same parties. A suit was brought by a person to recover a possession from a stranger of the mat property, claiming it as a heir of the deceased Mahan. This suit was dismissed on his failure to produce the succession certificate. A second suit was filed by him as a manager of the mat. So, in such case, whether the suit can be barred by res judicata or not, because already once the decision is taken. In this case, it is not barred. The second suit will not be barred because the person who has filed is in a different position as a manager of the mat. State of UP versus Nawab Hussain. These are some important cases. They may also refer on a particular type of a topic. So, with respect to the constructive res judicata, the case is State of UP versus Nawab Hussain. Just we need to remember this. If X is living in Pune, Y, his brother in Mumbai, X wants to file a suit of partition of their joint property situated in Delhi and Bangalore. Then the suit can be instituted either in Delhi or in Bangalore because their joint property is situated in Delhi and Bangalore. That is the cause of action. An immovable property held by a Y situated in Bhopal and a wrongdoer person Ali works for a gain in Indore. A suit to obtain the compensation can be filed at Bhopal, Indore. It's either Bhopal or Indore, he can do it. A resides at Hyderabad, B at Calcutta, C at Delhi. A, B, C being together at Allahabad, B and C make a joint promissory note or payable on demand and derive to A. A may sue B and C at any of these places, Allahabad, Calcutta or Delhi. Section 25 empowers the Supreme Court to transfer any suit. Section 25 deals with the transfer of petitions. Any suit appeal or proceedings from High Court to another court, from any one civil court to other civil court, both A and B or only A. So the section 25 for the transfer of petition from either High Court to some other High Court or any civil court to other civil court. Basically, it is from state to state or within the state one court to other court. That is under section 25. In which of the following cases can C set off the claim? In a particular claim, C can set off the claim. A sues C on a bill of exchange of 500. C holds a decree against A for recovery of the debt of 1000 rupees. If the recovery is more than what is required, what is the order of the payment, then he can set off the case. A suit may be dismissed under Order 9(1), where summons is not served upon the defendant in consequence of the plaintiff, where neither the plaintiff nor the defendant appears, where the plaintiff, after summons returned unserved, fails for 7 days to apply for the fresh, where on the date fixed for the hearing of a suit only dependent appears. In any of these cases, it can be dismissed. Who is a garnishee? We already had a question on the garnishee. Garnishee is a third party who is instructed by way of a legal notice to surrender the money to settle the debt or a claim. Section 10 of the CPC talks about the stay of the suit. Clerical or arithmetical mistakes in the judgment or degrees can be corrected under section 152 of the CPC. Section 152 talks about the corrections in the judgment subjected to the clerical or a mathematical, not the concept, the intent of the judgment. Section 152 talks about that. Which of the following deals with the plaint in an interpleader suit in the code of a civil procedure? Interpleader, it is under the order 35 rule 1. Interpleader, please remember the order 35 and rule. A suit for a compensation for a false imprisonment for a period of a limitation is 1 year. So if any false imprisonment is there within the 1 year, the suit has to be there. Which of the following is true rules framed by the Supreme Court with reference to the appeal to it? Here actually we don't have a correct answer. They are all the special law within the section 4 is not correct. They must be taking precedence under section 114 is not correct. So normally these questions which is not correct, then we have to be careful, because most of the time we think that one of them may be correct. So we should have more knowledge. So you simply have to refer to those sections, whatever is specified here. You can refer to the Bare Act for each of these things, and then you can decide whether it is covered or not. Judgment should be delivered to the parties or their pleaders in the open court by delivering the whole judgment, by reading the whole judgment, and by reading out the operative part of the judgments. All of these are correct. Section 34 of the CPC provides the payment of fine imposed by the court, payment of the compensation to the party, payment of the interest, none of the above. Section 34 talks about the payment of the interest. According to clauses 1, 2, 3 of the section 145, so immediately you can refer to the section 145 of CPC. It may render himself personally liable. He may only give a chance upon his property. He may undertake a personal liability. All of these are the answer. The word case used in section 115 of the Code of Civil Procedure is of a wide important. It means any state of the fact judicially considered. It includes civil proceedings, other suits, and is not restricted to any contained in the section of the entirety of the proceedings in the civil code. So this is the answer. B is the answer. The word is not possessed of a sufficient means in the order 33 rule 1. Again, here none of the answers are correct. So we need to refer to the Bare Act order 33 rule 1 and answer. Section 80 of the CPC is binding. Which are the courts? High Court, Civil Court, District Court. All of the above is the answer. Temporary injunction can be granted. Suo motu, ex parte, hearing both parties, none of the. Temporary normally is the ex parte, because other party is not available. So here, based on the balance of the justice, they will grant the temporary injunction. Right to appeal, it is a statutory right. There is a difference between a mandatory right and a statutory right. Statutory right has certain conditions based on the statute. So we should understand that. A decree can be final, preliminary, only primal, not preliminary, either primal, either preliminary. It can be either preliminary or final. Foreign judgment is defined under the section 2 of 6, section 6 of the 2. Which of the following is not of a civil nature? Right to take out the procession, right to worship in the temple, right to caste and religion. They are not of a civil nature because they involve the public or other parties. So in such case, and they also involve certain rule of the land. Wherever the rule of the land is there, where the government is involved, any action against that is not considered as the civil nature. In a suit where the doctrine of res judicata applies, the suit is liable to be dismissed. Doctrine of res judicata, we can expect at least one question. This is section 10, 11 and 12. Stay doctrine of res judicata and case where a case is pending in another court. These are all the important things. One of the questions may come in the exam. Under section 16 of CPC, a suit relating to immovable property can be filed in a court where a property is situated or where a defendant voluntarily resides or a carry on his business. In both cases, it can be filed, either a cause of action or where a person resides. Friends, the rest of the questions we will be covering in the next session. And I request you to please go through this. This will give an idea. It is very difficult to remember all the orders and sections. That is the reason we are allowed to carry out the BARE Act. But we should know which subject is related to which BARE Act. We cannot read the entire BARE Act in the exam hall to search for an answer for one or two questions. So this particular previous questions will give an idea where to look for. So I hope this session will be useful to all our friends who are appearing for the AIB, and please go through that. So I'll be giving more such sessions at least by 31st of January to cover more than at least 10 important topics, which will cover about 60 to 70 questions. So please go through this channel and subscribe and share to your friends who are appearing for the exam. Thank you very much.